Hello, NCW members, affiliates, friends, those that are part of our network. Over 200 people are online tonight. We are so excited to see you all joining us for this Supreme Court breakdown. Listen, the premise of this actual event was that we have had so much happen in the last week and a half with the Supreme Court. NCW realized we needed to get some of the heavy hitters on the line to talk about these cases that have really made an impact on Black women and our families. And we know that's where NCW focuses on Black women and their families and communities. And who better to come together than this power-packed sister lawyer lineup? Let me just say, as a non-lawyer on tonight, I'm so excited to have you on. We have three amazing sisters who are going to be giving us some insight on the cases. You're going to hear us talk about affirmative action. You're going to hear us talk about student loan debt. You're going to hear us talk about last year's Dobbs decision. There's going to be an announcement we're going to make tonight as well from NCNW. So for those that are on the line, we're over 236 participants. So I am just ecstatic about the response. With a short turnaround, that means this breakdown is needed. So I want to start with Sister Darielle Rodriguez. She is the Deputy Chief Counsel for the Lawyers Committee for Civil Rights. Now, Brother Damon Hewitt is our brother and friend. Unfortunately, was not feeling well tonight. But nothing like having a right hand ready to roll. And Sister Darielle, thank you so much for joining us tonight. We also have Sister Tona Boyd. Now, I've known Tona before her work with the Legal Defense Fund, but Sister Tona is the Associate Director Counsel for the Legal Defense Fund. She is an amazing lawyer, has done a lot of work. I just want to say Supreme Court Justice Ketanji Brown Jackson, she was there on the front lines. That's where I really got to see her do her serious work. And she has joined us tonight. She's sitting in for Sister Janae. Sister Janae is the president of LDF and has been an amazing partner in work. And last but not least, for the over now 265 people on the line, we have the one and only Janice L. Mathis, Esquire, who is our previous executive director of NCNW and now who is serving as the general counsel. So let me just say, for those that are on the webinar, and this number just keeps on ticking up, thank you all, my sisters, for joining us tonight. We're going to have a roundtable conversation. This conversation, quite frankly, is so important. We wanted to be sure that we got a chance to really weigh in on these issues. Now, I'm going to ask a few questions, and there will be time for questions at the end. For all of you that are online, I believe that the Q&A function will be opened for you. I want to thank Whitney Guilford and Bernadine Stallings from the communications team and public affairs leadership of NCNW for getting us rolling with this webinar. And make sure you let us know how this webinar works for you. So we're ahead of schedule. I'm about to jump into these questions. I'm so excited about this. So here's the first question, open question for all of you. I want to start with the big one, affirmative action. Affirmative action. This is an issue we have been talking about for decades, okay? We have seen so much information in terms of the media, but for our members of NCNW, our affiliates, and the friends of NCNW, can each of you share clearly what was the actual ruling first on the case, and then what it means for universities in this country? Because many of our folks have been asking, is this going to affect my HBCUs? Is this going to affect my PWI? I went to a PWI, Tulane University, and also an HBCU, Virginia Union. So what does this mean? So what was the ruling first? And exactly what does it mean? If you don't mind also talking about your role in some of these cases as well and those answers. So I'm asking Sister Tona to get us started, and then I'll come down the row.
Sure. First of all, thank you so much, Madam President, for having us tonight. I'm just honored to be a part of this conversation because it's an important one and there's a lot for us to unpack. In terms of the affirmative action cases, so in terms of LDF's role, we represented 25 Harvard student and alumni organizations made up of thousands of Black, Latinx, Asian American, Native American, and white students, as well as alumni. And we were amici curiae, or friends of the court, in the Harvard lawsuit. So we presented the court with, so first of all, at the trial level in these cases, some of our clients were, client organizations were witnesses during that trial back in 2018. And then we submitted briefs and oral argument and briefs before the Supreme Court regarding the affirmative action programs that were at issue. So what did the court decide in this case? I think it's really important to set the record straight in terms of what the court actually did here, because I think we've seen in the media a lot of alarmist language with respect to affirmative action being dead. And so I want to start off by saying, first of all, the court's opinion itself specified that although the court struck down the affirmative action programs at issue at both Harvard and UNC, the court did specifically state that nothing prohibits universities from considering an applicant's discussion of how race has affected the applicant's life.
Okay.
So I think that's really important to come out of the gate and say. This ruling does not diminish our responsibility or our legal ability to ensure that the college admissions process remains fair and accessible for underrepresented students of color. So I think young people need to know that they have a right to bring their lived experiences to the page when it comes to applying for admissions to colleges and universities. And they have the right, as the court said, to express their experiences and fortitude, whether that's in overcoming experience of discrimination or other ways in which race has intersected with their lives and experiences. So I think the decision is alarming, and I don't want to undersell that. And I know we'll speak more about that, but I think it's important to note, exactly what the court decided in the case.
So that, first of all, you just stopped me in my tracks, because I think a lot of people have been hearing affirmative action is gone. We have struck it all down. And see, that language as really taking a lot of advocates to the next level. So how do we advocate? What do we do? How do we respond? There's now over 300 people on this call, and I'm seeing the questions already like lighting up, because I think that there's a misnomer here. And Darielle, if you don't mind, because Tony's got us really set up here, as you're thinking about the University of North Carolina and Harvard, are there other universities that we need to be considering? Is that going to affect other universities? I want to make sure that we kind of clear that up for our listeners today.
So thank you, Madam President, for having me and sending my regards on behalf of our President and Executive Director, Damon Hewitt. Really appreciate the entire NCNW team for putting this really important program together. So the Lawyers Committee for Civil Rights Under Law, along with co-counsel, we represented multiracial groups of students and alumni from UNC at Chapel Hill and at Harvard. And the Lawyers Committee was the only civil rights organization that litigated both cases since their inception. And we were also the only organization that presented oral arguments in the Supreme Court when the cases were argued. So that oral argument was presented by my colleague, David Hinojosa. And so I echo everything that Tona said about the opinion. And as you all know, Justices Sotomayor and Justice Jackson filed very powerful dissenting opinions. And notably, Justice Sotomayor, in her dissenting opinion, cited the testimony of several of our clients about how race was an indispensable part of their identity. Particularly, it's stating that universities should be able to consider race as one of the many factors in admissions. And so you asked about other cases in the pipeline, and there are various cases in the pipeline, including one involving the University of Texas. And I think what's going to happen now is that a lot of universities are going to go back and look at their admissions processes to determine whether or not they comply with the law as it now stands. And to build upon what Tona said, This case dealt with the programs at Harvard and at UNC, right? The ruling did not explicitly overrule the court's affirmative action precedents, which the programs at Harvard and UNC were modeled after. But at the same time, we know that the decision really pared back the circumstances under which race can be considered in higher education admissions. So what we've been doing at the Lawyers Committee is really calling upon universities in this moment to bring their most creative minds to the table, to really think about how do you ensure equity, inclusion, diversity on college campuses. I have a colleague, Maya Lubin, who does a lot of grassroots work with universities. And one thing that she always says, and I want to credit it to her, is that affirmative action was never meant to be the silver bullet, right? There are a lot of tools in universities' toolboxes that they can use. And right now is the moment to really be creative and think about what else can be done to ensure that there aren't rollbacks and that we can continue pushing for equity. We know that this ruling is going to have a negative impact on representation of Black and Brown students on our campuses. I don't want to make it seem like that's not going to happen. We saw that happen in California. However, I think that we just really need to keep our foot on the pedal and ensure that we are being responsive and that we're doing everything that we can to ensure that our campuses are equitable.
So I think you all are starting to, the questions are popping in like popcorn, which is great. And Janice, I'm going to bring this to us because a lot of we got NCNW members here. We got some parents on the line that I see. And I want to, same question, but the angle here is, will it affect HBCUs? One, and if affirmative action is not gone, then does anything change when you apply for college? What does something change now in the application process? Because Tona started to deal with that a little bit to say, listen, share your lived experience. And your experience as a person of color, an African American person, a Latin person from a tribal nation, right? An Asian American, whatever your experience is, saying that. But we have our listeners asking, but what does this mean? Is the HBCU going to be affected too? And then is this effective immediately? What's going to happen?
Well, I think it's important. First of all, I want to thank you, Siobhan, for your leadership in bringing this important discussion to our members. And
appreciate that.
And then I got to shout out the LDF and the Lawyers Committee. These are real, live, tough litigators. They don't just play lawyers on Zoom like I do. These are the folks who go into the courtrooms and do battle, and it is not easy. The work is very difficult and very detailed. So kudos to you. But I think Chief Justice Roberts sort of lays out a little bit of a roadmap. I just want to quote his language so that it's clear. College admissions programs can consider race to allow an applicant to explain how their race influenced their character in a way that would have a concrete effect on the university. He did not say to make your life better, to glorify your parents and appreciate them for all that they've done for you. It says to have a concrete effect on the university. And this takes me all the way back to 78 and Bakke, which diversity was never about, was never about repairing the wrong that had been done in the past, but to recognize compelling state interest in diverse student bodies.
Yes.
So that, to some extent, has not changed that much. But I would just say to parents and to students both, think particularly about the time that you ran for student council president and you were to lead a multiracial coalition to elect you. I was president of my class in Greenville, South Carolina. My class was 20% Black. So I had to appeal across that line. To those kinds of experiences, I think, is what the court's going to be looking for. What is it about you that makes you different, and how did race play into that? In terms of how it will affect HBCUs, I confess I worry a little bit. If race is circumscribed, and particularly for highly selective programs like the vet med program at Tuskegee, or the medical schools, or the engineering program at A&T that are very competitive, that courts might be tempted to say, well, if you're using admitting only Black students or mostly Black students, but you're getting more and more white applicants to these programs, might come under scrutiny as well to say, are you using race impermissibly to keep your HBCU?
Tony, I see you. Come in there, Tony.
So one thing I wanted to also flag that I think may be an impact of these decisions is, we know that HBCUs have always stepped into the breach when it comes to educating Black students and Black leaders in this country. When we were denied entry wholeheartedly under law from even attending a lot of these universities. And so HBCUs have always stood in the breach in preparing our Black youth to enter the workforce and to be leaders. But we also know that HBCUs have long been under-resourced. They've been denied resources actually that they are entitled to and were entitled to. And so I think part of what we may see happening here is we know HBCUs are under-resourced right now. They have been under-resourced. We may see a number of Black students applying to more HBCUs now, as opposed to, primarily white institutions and universities in light of the chilling effect of these decisions. And so now we will have HBCUs even in more need of additional resources. So I think part of what that means for us is we have to continue to support our HBCUs. We have to continue to call for their full funding. We have to hold Congress's feet to the fire when it comes to providing full funding for HBCUs. And I think Madam Vice President Kamala Harris has spoken very eloquently about the importance of supporting and funding our HBCUs, and we've got to lift that up.
Yeah, that's go ahead. Janice, you want to add something, Janice?
Yeah, I was just thinking about HBCUs. Not only are they under-resourced, but they're already very popular. Places like Howard and A&T and FAMU. I think outgoing President Frederick estimated they expect to get 60,000 applications to Howard over the next admissions period. And so what that does, it just underscores what you were saying, Tona, is that they're going to need even more resources. The kids have already figured out they want to go to HBCUs because they feel, they feel valued, they feel comfortable there. And most doctors graduate from HBCUs, many professionals. These schools are very effective.
That's right.
Bring out professionals from their programs.
Let me tap into this race conversation because and the question and answer chat is amazing right now. Tona, go ahead. I see you.
I just wanted to say one more thing about what these affirmative action decisions do and do not speak to. We've heard a lot about diversity, equity, and inclusion, recruitment, employment.
Yes.
These cases do not speak to those contexts. And I think that's very important to highlight and push. I think there's a lot of concern that may be the next frontier in terms of attacks we're seeing with respect to diversity and inclusion. But these decisions don't cover outreach, recruitment, affinity groups, employment, contracting, race neutral policies, K through 12 admissions. And so I think it's really important for us to note that. It's super important that we are continuing to double down to support those types of programs because we're going to need them more now than ever, as we may see the chilling effect and the slowing of the pipeline when it comes to students being having access to these elite institutions.
Dariella, give me your last word. I see you.
Yes, echoing everything that Ms. Mathis and Tona just shared with respect to DEI programs in the workplace.
Yes.
It's really interesting because recent news articles are saying that some big companies are letting go of their chief diversity officers. After the wake of George Floyd's murder, we saw a real push by corporate America.
Yes.
To really double down or make for the first time commitments to increase their Black employee representation. And now we're seeing retreats from corporate America. So I think just as we have to push on higher education institutions to continue exploring creatively ways to ensure diversity on their college campuses, we also have to call upon businesses to not retreat from their DEI efforts.
And let me just say, NCNW is publicly supporting that stance. We are in the process now of preparing ourselves as we're thinking about economic development and really long-term pipeline leadership, is how we ensure that we continue to hold corporations, institutions, quite frankly, all sectors accountable to advancing not only this framework of equity, diversity, inclusion, but implementing and executing it in their policies and their practices. So the question and answer chat is going crazy. I'm going to add my question and connect one. Race is such a hot topic, right? I don't know, for folks that are Black and brown and that people of color in this country, this is just our life. This is our way of life. But for some reason, mainstream America still has this fantasy about race. Why do you think issues like affirmative action are still difficult for folks to really grasp? And I'm thinking about this from a legal standpoint, because now we're talking about the law. When the Supreme Court makes a ruling, when policies are made, I'm thinking about the policies that have passed in school boards across this country, in states across this country around, Black history in schools. This is all connected for us. This is not just affirmative action. This is not just one case. This, quite frankly, is a movement happening through this country. Why is this such a hot button issue for us? Anybody want to jump in on that?
Let me say about race. Race has been a hot button issue from day one in America, from 1619 to now. And what you saw was race during most of our history was used to exclude Black and brown people from public accommodations, from education, from transportation, from healthcare. It was used to exclude. So rightfully, it became a suspect classification. Mm-hmm. Classify people based on race. But then that got turned inside out, and the lawyers can talk about it better than I can, and turned into something called reverse discrimination. That we're not going to categorize, you can't go to the bathroom because you're Black. Well, now you're keeping me from getting the best jobs because I'm white. And that's where this race tension comes from. It is unfortunate. But the other thing I wanted to say is that 13 Republican state attorneys general are cautioning 100 of the biggest companies in the United States to be careful about DEI, because they may run afoul of the way that race can be used permissibly beyond applications for college. That is a chilling effect as well.
That's a chilling effect.
But the good news is state attorneys general get elected. And so
that's right.
We're talking about advocacy at the end of the program, we can talk about how we make sure that we have state attorneys general and other elected officials who understand what their constituents need.
I love that. Tona, I see you.
Yeah, I just was going to talk a little bit about what the court did with respect to race this term, because I think it was a little bit confusing and muddled when we look at some of their decisions. So obviously we know that the conservative majority of the court ignored the role that race plays when we think about education in this country and the impact of having been excluded so long from our country's educational system. But then we also saw this same court hold in Allen versus Milligan, which is a case that LDF litigated and argued in front of the Supreme Court that was about vote dilution and racial gerrymandering. And there you had the court acknowledging the very real role that race and race discrimination plays. And in their opinion, where they upheld Section 2 of the Voting Rights Act and upheld the lower court's decision, which said that Alabama needed to go back and create a non-discriminatory map that included 2 majority Black districts. And so it's confusing to see, on the one hand, the court recognize the history of discrimination and the role of race in a voting rights case, but then turn around in a case about education and find something very different. And so I want to raise up Justice Ketanji Brown Jackson. You know, she had so many beautiful moments this term, and what a what an amazing addition to this court and to this country's really future as a democracy. One of the lines that she had in her opinion in the affirmative action cases, I think, is very powerful. She said, "Deeming race irrelevant in law does not make it so in life." And I think we all know that's true. In order to truly, honestly engage with race, and in order to truly dismantle systems of racial discrimination and racial inequality, we've got to talk about it and call it out. We can't ignore it. We can't continue to operate and accept this facade of a colorblind constitution, which Justice Jackson also called out. You know,
yes,
this country has not been colorblind, and she reminded her colleagues and this country and the public of that. And so I think that's something that's important for us to note when we think about these cases. And I want to say that at LDF, you know, we are going to continue to advocate, to litigate, and to educate about these issues, because I think, Siobhan, you started to raise what we're seeing in terms of the assault on truth and efforts to erase, you know, Black people, people of color, LGBTQ people's lived experiences from our classrooms and from our books. That's all part of this same enterprise that we have to be on guard about, and we have to continue to speak up and speak out against.
I'm about to sign up for us having a summit on this. I'm so moved because, and this is why the chat is crazy. It's really getting clarity and gaining clarity in a few places that have even been tough for me to even explain. Tony, you just did a masterful job of that. Daryl, I see you jumping in, so let me give you the floor.
Sure. I think that the backlash is really alarming. And our organizations like the Lawyers Committee, organizations like LDF, we need to ensure that the narratives of our clients are out there. That's why the Lawyers Committee, in the affirmative action cases, we represented students, including Black students, who talked about their lived experience of going to a predominantly white institution that has a representation of Black students that is much lower than the surrounding community, and the hostility that's experienced, the isolation that's experienced. And so I think we need to continue to push back against that narrative and lift up the stories of our clients in the litigation that we bring.
Go ahead, Janice.
In earlier opinions, I think it was maybe 2013 or 2016, the opinion said you need a critical mass of Black students. It's not enough to have tokens. It's not enough to have here or there. You need a critical mass of them. So what I'm concerned about, and really a question, when Roberts and the majority key in on the individualized experience, short shrift to the systemic and endemic experience of being Black in the United States. You can't separate what happens to you from as an individual from what happens to you as a person of color, a woman of color in this country. And so what happens to that critical mass? I didn't see any discussion of that in this recent opinion about making sure that you're not tokenized when you get to these selective campuses.
Yeah, and I think for me it's personal. I mean, I attended Tulane University in the 90s, and recall the David Dukes of the world running for office with his helicopter flying over campus. And this New Jersey native was in the heart of a member of the Klan running for governor, right? And so we're talking about 25, 26 years ago. Now we're in this situation where we're hearing about the hostility, the experiences of our young people. Many of our affiliates are organizations that have presence on collegiate campuses, Divine Nine members, organizations that are engaging in those spaces. And so, these are some of the concerns that we have as NCNW, which is why we've asked all of you to really give context. First, I want to just welcome all those that come. We have over 340 participants that are on tonight having this Supreme Court case breakdown with three of the baddest sisters. I'm so excited about this because we're really digging in. The Q&A chat is going crazy. I might have to start letting them ask questions before I get to mine. But I've got to get to this next part. Student loan debt. Hello, somebody. Student loan debt. It is a major issue. And I want to just shout this out. It is not just for young people, but of adults of all ages. I'll be 45 on Friday, right? And I just paid off my student loan debt. 45. I was in school in my 20s, right? I was a collegiate athlete, so I didn't pay for the undergrad, but when I got to my master's program, that was on me. And that took 20 years to pay off. So I wanted to say this is about seniors who are in their 60s and 70s. And guess what? Either paying off their loans still or loans of those that they were guardians of. This is a major issue. Can you talk a little bit about this case and this ruling and what impact will it have on those of us that still have student loans? Because I think sometimes people have asked so many questions about the student loan debt issue. You know, pay your share, do your part. And I don't think people realize how much privilege they have as we look at the disparities in terms of economic access and wealth and the wealth gaps that are present. So can we talk about this case just a little bit? We've got about 10 minutes left to talk about the rest of the world. We're going to go ahead and get all of it in the next 10 minutes. So let's hit this and then we'll sneak in Dobbs. I'm going to try to sneak that last case in, but if not, I feel like we got to have a part 2 because this is just too good. Let's talk about student loan debt. Tona, go ahead, jump in.
Sure. So just to briefly summarize what the court did, I think we know that the court struck down the student debt forgiveness plan that the Biden administration had put forth. And specifically, just to simplify what happened, the court basically said that the HEROES Act, which was the authority that the Department of Education used to implement the program, the court said that that act did not explicitly allow for this type of debt forgiveness. And so because of that, they said because the Department of Education wasn't authorized under the act to take this action, the program is therefore unlawful, unconstitutional. And I want to call out one of the doctrines that the court used there because it's something that I think could really have a significant impact on the ability of our executive agencies to take action to combat the issues that are facing us, whether that's climate change, student debt. They're really important issues that these agencies are trying to tackle. But the court articulated a doctrine called the Major Questions Doctrine. And that is where they claim that if Congress wants to do something that could be a decision of vast economic or political significance. So if Congress wants to grant an agency to make a decision of vast economic or political significance, Congress has to say so specifically and clearly in the bill that authorizes the agency to take action. So this is a relatively sort of new doctrine that is kind of catching a little bit in this particular court. We saw earlier in this term that they did the same thing with respect to the Clean Air Act and efforts to limit carbon emissions. They said, listen, Major Questions Doctrine, guess what, EPA, you do not have the authority to regulate emissions in this way. And so we're striking down your effort to do so. That could really change the landscape when it comes to trying to affect change through our executive agencies. And so I think we've got to keep an eye on that. But that was the underlying holding in this case.
Darielle, go ahead.
And this case was about the HEROES Act, as Tona said. So, you know, right after the ruling, you saw President Biden do his press conference and announce exploring other ways to forgive student debt. And at the Lawyers Committee, we are urging the administration to act swiftly and with urgency because there are several tools that the administration has to deliver student debt relief to millions of borrowers and families. And you asked about the impact of this ruling. The Lawyers Committee filed an amicus brief in the case, which was joined by 21 organizations. And in our brief, we argued that the student relief program would have provided critical relief to millions of lower income borrowers, including millions of Black and Latinx borrowers who have disproportionately shouldered the severe impacts of the COVID-19 pandemic. With respect to student debt generally, and you touched a little bit on this, we know that Black communities disproportionately shoulder student debt, and that's because of the nature of intergenerational wealth. We have less intergenerational wealth to rely on, and so disproportionately tap into student loans to pay for our higher education. And what that means is that that limits our ability to buy homes, to start small businesses, to save for retirement, and to just generally build wealth over our lifetimes. And this is also particularly true for Black women. Black women carry the highest student loan debt burdens and tend to finish their post-secondary education with $15,000 more student debt on average than white women. And the average Black student loan borrower takes on nearly 50% more, 50% more debt for a bachelor's degree than his or her white peers. So we see how important debt relief is, and we really are continuing to push on the administration to do everything that they can.
Yeah, you said 50%. I want the people to hear it on the screen. 50%. Go ahead, Janice.
And the administration did announce, I believe this past Friday, that they were proposing now $39 billion in debt relief for up to about 800,000. The majority opinion disturbed me in the sense that it seemed fixated on the size, the amount, the dollar amount of the of forgiveness. Oh, $40 billion a year, $400 billion. How dare we? The Congress should be appropriating and getting into how much money was involved, but compared to what?
Right.
0.13% of the gross domestic product of the United States. $430 billion is a lot of money, unless you're comparing it to the entire United States budget. It's minuscule.
Yeah.
And then talking about the political, because see, what they want to say is that Biden is using this to bribe his followers into voting for him. Well, so be it. That's what politicians do. They attend to the needs of what their constituents. I would be upset if he were not thinking about what Black women need and what people who are progressive need in their financial lives. And it just seemed that there was a lot of concern about the economics and the politics and not so much concern about the law.
And that's the call out that's important tonight. And somebody in the question and answer said, I'm 71 and I may die before I pay off my student loan debt acquired for my doctoral degree. And let me just affirm that moment, right? To the anonymous attendee. One, we speak life over you, but let me just say you called out something deep, which is that at this age, you are still having to carry debt of a doctoral degree. And this is not just about your educational attainment, right? So student loan debt carries and follows you as professionals, as those that have specialties. I mean, literally, I have friends, sorority sisters, council members that are doctors, lawyers, architects, teachers, principals, and they are paying thousands, tens of thousands, some in the six figures because of how much debt they have to take on. I know I see the timer, so I've got to sneak this in. All right. So somebody in the chat just said part 2 is a must. And so we got to figure that out because you all are just giving us life here. There was a costly ruling in June of 2022, the Dobbs decision. And I want to just call it out now. This conversation around Roe v. Wade has been a discussion for over 5 decades, but there have been major issues facing Black women in health right now because of this ruling. And I want to also call out the elephants in the room, which are a lot of connections to religious beliefs when we think about this issue of abortion. So can we talk about the Dobbs decision? Give a little bit of context for what you all can share from now 1 year out, seeing the implications. I'll also offer some things, and I do want to share hot off the press a statement from NCNW as well once we hear from the panel. So in response to the Dobbs decision from last year, impacts you've seen, let's talk a little bit about it. Go ahead, Tone, I see you off the line.
So I think we know, especially the group gathered here today, that racial justice and reproductive rights are inextricably linked, right? And overturning reproductive rights disproportionately harms Black, Brown, and low-income people, the folks who are most impacted by these systemic inequalities that we've been talking about tonight. So I think we know without a doubt that Dobbs is disproportionately and disparately harming Black women. And when we think about the maternal health crisis in this country and among Black women, it is just really a sobering moment to think about what this decision will do to access to critical reproductive care. We know that people of color are more likely to live in states that have the most restrictive abortion laws, and that at the same time, they are less likely to have the health insurance necessary to get access to the care needed. So I think we cannot understate the sort of economic impact of this decision and the health impact. And I think it's part of the reason why we have to continue to advocate for our communities and for resources for our communities.
Yeah, love that. Darielle, go ahead.
I can't believe it's already been a year, right?
It's been a year.
It's been a year. And that decision eviscerated decades of precedent, and it moved economic freedom completely out of reach for many women. But we know for Black women in particular, they already face significant barriers to accessing abortion, even before that ruling. And we filed an amicus brief in that case, explaining in great detail the effect that a negative ruling would have on Black women in particular. We highlighted in our brief some of the points that Tona highlighted, that for many reasons, Black women suffer from a lack of sex education, a lack of health insurance. They live in states where there's a failure to ensure reasonable access to effective forms of contraception. And all of these things contribute to higher rates of unplanned pregnancy. And you might notice a trend, but the dissenting opinion in Dobbs also cited our amicus brief for the position that women who do not have adequate health coverage before and after pregnancy face these significant barriers. And even when they do have adequate health coverage, it does not solve the problem that health services may be too far away, or that access to contraceptives is not universal. That is not something that everyone has access to. And so a year later, I think as an organization at the Lawyers Committee, we really had to pivot and address sort of the various issues that arose out of this ruling. It implicates privacy rights issues, for example. It implicates criminal justice issues. We know that there's an overcriminalization now of abortion. Well, what does that mean for Black communities and Black women? For privacy rights, right? The fact that you can now be prosecuted in some states. What does that mean when you're Googling and trying to find abortion services, maybe in a state other than the one that you live in? And so we are just trying to stay abreast of those issues and do work across different programmatic issues to ensure that these rights are protected from a holistic perspective.
And if you think of where we live, you may be in a state that has not expanded Medicaid. You may not have adequate access to broadband so that you can't do telemedicine. You may have experienced hospital closures in your community, and then you're underinsured, and you may not have a credit card that you can put a $500 airplane ticket and another $500 for a hotel bill. It is bound up in so many of these systemic inequities that our people, and not just us, young women too. A sexual abortion ban, I don't care what color you are, that is punitive. Not allowing women to get DNCs when they've had a miscarriage and to carry and then compromise their future fertility so that you can prosecute somebody, the doctor or the woman, for having had a procedure. It is, I wouldn't have identified it as something in the American way. It is just cruel and unusual.
It is cruel. And as a mother who has had 3 miscarriages, who's had to have those procedures, I think about my life would have been lost with one of my miscarriages. I would not be here to have this conversation. I've had 5 pregnancies and have 1 child. And I tell you, that this ruling for me has been personal, and I've watched it, and I've watched religious context. Many of you all know I am a minister, so I have the context and the training to understand why people believe in life. I do believe in life. I believe life begins at conception, but I don't believe in the government's right to make decisions and agency for our bodies. I need to say that. And I want to just share very quickly, NCNW has made a public statement. I'm so proud of our board of directors under the leadership of Dr. Lois Keith, our executive committee, and our affiliates who align with us, that NCNW rejects and will resist efforts to deny, reduce, or extinguish freedoms, whether by legislators, courts, or extremist activities or economic circumstance. We believe that sacred among civil rights that NCNW knows passionately, we believe in our sacred freedom of every woman to make a decision about her own body. During the convention, we passed a resolution solidifying our commitment to protect the Black woman's agency and accountability over their own lives. So I want you to hear this live. We do not presume to dictate how a woman chooses to manage her health or the health of her family, and neither should any other person or system of oppression. So that statement will go out fully. We're going to align it and let you all know about this work. I'm hearing it, I see it in the chat, so I'm going to hit it. We got one more case, at least to highlight before we go, because this is so important. And that is this. There was a case concerning the rights of private businesses to refuse services to protect the classes due to the First Amendment right to freedom of speech. Can you talk a little bit about the 303 Creative LLC versus is it Elenis or Elenis case that was ruled also on the very same day for the HEROES Act? Anybody want to jump in very quickly before we transition into our final Q&A?
I'm happy to jump in quickly.
Jump in, Darielle.
Another case we filed an amicus brief in. So in that case, the court held that some businesses have a constitutional right to discriminate against LGBTQ+ people in public accommodations so long as they are engaged in expressive conduct, such as creating custom artistic works. And Madam President, I think earlier you had mentioned that this case involved a wedding website designer. And it involved Colorado's public accommodation law, which prohibits discrimination in public accommodations, including businesses, on various protected categories, including sexual orientation. And this case was interesting because the state of Colorado stipulated that this business was engaged in custom artistic works. Were they? That was something that they stipulated to. And so the court really focused on that and said, well, they were engaged in custom artistic works here, and they found that it was a violation of free speech rights. Now, why were we concerned about this case as a racial justice organization? For a few reasons. One, public accommodation laws are critically important. We know that from our history at the federal level, civil rights laws that apply to public accommodations were instrumental in defeating Jim Crow and in transforming the experience of Black people and other protected classes for decades. They outlawed segregated water fountains, segregated lunch counters, and they banned laws that required Black people to ride in the back of a bus. Now, these laws continue to be critically important today. We've filed briefs where we talk about how Black consumers continue to face high rates of discrimination in public accommodations, including when they're shopping, right? Like shop and frisk, that is still a very real thing. And so these laws continue to be critically important. And so what we're concerned about here is, one, we know that LGBTQ Black people suffer from disproportionately high rates of discrimination, including in public accommodation. So that intersectional lens, right? And two, that it's a very dangerous precedent to say that public accommodation laws can be exempted by this free speech interest, right? So what that means is that if businesses are allowed to intentionally discriminate against LGBTQ+ folks for reasons rooted in free speech interests, inevitably they're going to seek to discriminate against other groups too, right? Against folks on the basis of race, on the basis of sex, and in other protected categories. And so we are really concerned about this. We really think that there needs to be a stop in the spread of this undermining of our core civil rights protections. And we're going to continue to remain vigilant to ensure that Black consumers, including those who are LGBTQ+, are able to really participate fully and freely in our economy.
Others want to weigh in?
I just want to quickly say, picking up on what Jarielle highlighted about how important our public accommodation laws are and the prohibitions against discrimination there. I mean, think of all of the quintessential civil rights moments. Think of folks sitting at the counters to integrate lunch counters, et cetera. Think of the important and landmark cases that were hard fought. We also filed a brief in this case, and we referenced back to a case that LDF actually litigated back in 1968, where a barbecue owner wanted to exclude Black people from patronizing his shop because of religious belief about whether or not Black people should sit in the same place as white people, right? And there, the court refused to allow that type of discrimination based on race. And so I think we can't underscore how important and impactful these decisions are. And it also reminds us, I think, about how important it is to know our history, right? Yes. And to be speaking out against these moments where they are not only trying to roll back hard fought rights, but they're trying to act as though that battle never happened, right? And so I think this all ties together in a way that is a powerful call for all of us to be speaking up and speaking out against these efforts, not just what's happening in the Supreme Court, but what's happening in legislatures across the country. We can't afford to be silent now.
Janice, I'll let you close out there.
Well, I don't really have anything to add, except it seemed to me that the court was very non-specific about what is the limit of interest. Right. I have a sincerely held belief that I don't believe in gay marriage. Okay, well then modify your website. You don't have to go into all about that. If there are other ways to reach a just result other than saying you don't have to serve them. That seemed to me like a reach, and in other contexts could be very dangerous for lots of people.
And let me just say this, and I see our chair of the board is actually on the line. Lois Keith is here. I see you in the Q&A chat. And I just want to offer this with the NCNW folks on the line. We're going to have to do this again. I can sense we had over 355 people jump on tonight with this kind of turnaround, which means advocates are serious about this. And with this, in the last 3 minutes, I want to just close with this. And give you all last word too. And that is this conversation with the 60 questions that we have here, which we're not gonna be able to get all to, but we are realizing that we're going to have to now put our boots on the ground. I want you to think about the Supreme Court makeup right now. NCNW is nonpartisan, but we are factual and clear on the implications of elections and the selection of Supreme Court justices. Think about 2016. 2016, Donald Trump was elected as president of the United States and identified two massively conservative justices to serve on the court for a lifetime, I want to keep the forever, until death do them part from the court. And what we are seeing is a real major backlash to all of the progressive work that's been done for civil rights and human rights in our country. The organizations you see on here tonight, Lawyers Committee and Legal Defense Fund, have been for decades supporting and litigating on behalf of Black people and on behalf of people of color and marginalized communities in our country. They are on the side of right and righteousness for legal protection. And I want to just publicly say, your presence tonight and the presence of NCNW, who for 88 years has been in this fight. We're going to continue working together on these issues. There's going to have to be a part two. I don't know what we're going to do, but we're going to do something soon, because what I'm seeing is that we're going to have to get our boots on the ground around voting. There are elections coming up in 2023, and the presidential election is coming up in 2024. And what we have to think about is these elections have consequences. When the elections don't go in the favor of policies and practices, not partisanship, policies and practices that support the interests of our people. And so for those of you that have joined us tonight, you've heard it from those organizations that have litigated and NCNW who has supported those in litigation. So I know it's the top of the hour. Not fair that we went through that fast, but let me just say, I hope that our listeners learned really tonight how amazingly important it is to support our organizations. Please support the Legal Defense Fund. Please support the Lawyers Committee and continue supporting NCNW. We are so honored to have all three of you on this panel tonight. I personally want to thank you because you could be somewhere else on a Monday night. But I want you to know that your work is not going undone. Our members are in the Q&A telling you how much they appreciated this. And someone just already said, we're already looking forward to session 2. So I tell you all on behalf of NCNW, thank you so much for all that you have done in this work. Continue fighting. NCNW, keep pushing. Don't forget to continue keeping up with your emails. Watch us on social. We were live tonight on Facebook. Folks are talking about this session because we've got 3 sisters who are ready to give you what they've got. So thank you all. Have a wonderful night, everyone, and enjoy the rest of your evening. Thank you all.